And at the end of the case, he flew up to Albany, New York, where my office was, and just to basically finalize the settlement. And I walked into the conference room just to say goodbye to this nice guy, Dale. And he gets up out of his chair. He walks over to me and gives me a huge bear hug. And he's squeezing the life out of me. And I'm like, man. And then he whispers in my ear, I love you. And I'm like,
Wow.
man, that's why I practice law, to have a profound impact on the lives of the severely disabled. So I'm not in personal injury law to help people with a broken arm or a twisted ankle or something like that. I want to represent people who are either their estate if they've died, which is most of our cases, brain damage, paralysis, loss of limb, blindness. So it's really those categories. So it's kind of easy to figure out the number one criteria for accepting the case are those five criteria. And so we have a very small caseload. We have 28 active files. The budget that we have in our firm is small. I absolutely love it though. It's like I look forward to practicing every day. And to this day, I can't believe that people will pay me money to do what we do. So I love it so much. The senior partner of my firm, I work for a nationally prominent catastrophic injury law firm. And the senior partner says to me, you want to try your first case? I said, sure, why not? Let's do it. And so he gave me 6 days before the trial a brain damage cerebral palsy medical malpractice case.
Wow.
Now, granted, I've got no idea what I'm doing. So I'm going there, and the senior partner says, don't worry about it. I'll be in the courtroom at counsel table sitting with you. We're going to be fine. You'll be fine. If there's a problem, I'm there for you. This guy never showed up.
Oh,
And
crap.
so I'm in court, a young kid. All the attorneys are about 30 or 40 years older than I'm on the defense side. And I'm like, what the hell do I do now? So what I did was there is a recipe for success. I read transcripts of trials by one of who I consider the master trial attorney in the country, Thomas More in New York City. And Thomas More, what I found out by reading his transcripts, he tries a case exactly the same way every single time. The words are the same. Everything about it's the same. So I'm sitting there. I've got his transcripts with me as well. I'm just reading word for word what he says. The judge comes flying off the stand at a break, and he goes, the judge's bench, he goes, that is the most brilliant questioning I have ever heard. And I'm like, yeah, Judge, I got it. This is easy for me. But the reality, I was just reading a transcript by another attorney. So, but Michael, the funniest thing is we get done with that trial. The only case in my career where I've recovered more than the insurance coverage was that case. And so I get done, and one of the jurors afterwards comes up to me because I always talk to them afterwards, and they said, I have to tell you, that one defense attorney was absolutely brilliant. And I'm said, oh, because it was a study in contrast. One attorney was brilliant. The other attorney was totally inept. And I said, oh, you mean this guy? And they go, no, no, no. The other guy. And I'm like, the other guy was horrible. Are you kidding me? But see, the point of that is the way jurors perceive us is so completely different from the way that we perceive things.
Yeah.
And that's the reason why, Michael, early in my career, I began doing focus groups to find out not what the result of the trial would be, but what are the questions that I'm not asking that I should be asking. So I've spent a large part of my career helping other lawyers and other law firms do focus groups to help benefit their biggest cases. I was at a trial lawyers college regional, and a young attorney, I'm sleeping in a bedroom with a stranger, right? It's a young attorney, he's with me. And he's like, I can't wait. I'm just out of law school. I can't wait for my first trial. This is going to be great. And he's like brimming with hope and vigor, right? And I said to him, you know what? You don't get to be in the courtroom unless you master the business of law first. And so much more important than mastering trial skills, which is something very few people actually get to do. It's much more important to master the business of law, how to run a business. Because if you don't do that, you're not going to be able to get to the courtroom. And so spending more than 50% of your time on business development, that's what the people do who make the most. It's just a matter of fact. I've learned that. And through the masterminds that I run nationally, I've learned the most successful lawyers, that's what they do. And what we use is what's called the 12-week plan to prepare for trial. And that is in my book, The Law Firm of Your Dreams. So as we go 12 weeks before a trial, week by week, we go through what the secretary is going to do, what the paralegal is going to do, what the attorney is going to do, and we put it in week by week in the 12-week plan. And so by the time we get to the trial, everything's done.
That's awesome.
Motions in limine have been served, verdict sheets, the whole thing. It's all done and over with. Because what I found, Michael, is in our cases, week by week, we do essentially the same thing with almost every case. There's very little difference. Deposition summaries. We videotape depositions. We have to create the excerpts of the videos and so that they can be played at trial and things like that. It's all the same. Focus groups. Well, we always do that. So let's get that planned out 12 weeks before trial rather than the week before trial. So that is the best way of relieving anxiety about a trial, is to be prepared. When you have a trial and you stand up in front of the jury for the first time, what is the most important thing that you can do? Well, screw your notes, throw the notes in the garbage can, and bond with the jury. But more importantly than that, you need to build credibility with the jury. And how do you do that? Well, it's really hard, but if you share your biggest danger point with them. So, for example, I represent a guy, Curtis, who was a passenger in a tractor trailer. He was seatbelted when he was killed in the wreck. After the crash, they did an autopsy. It turns out the drug screen showed this guy, Curtis, had cocaine throughout his blood system everywhere. We are not going to have any explanation. We're not going to have any excuse. And we have no idea how that happened. And if you feel, based upon what I've just told you, that maybe we should just be done and over with here, that's no problem at all. How do you feel about this? And what they might say is, well, wait a minute. What the hell does cocaine in his system have to do with a seatbelted passenger in a truck wreck? The other trucker was at fault. This guy, okay, maybe he had some issues with drugs, but the reality, he didn't deserve this to happen to him.
Yeah.
They will rally to your defense when you reveal early on your most vulnerable danger point. When you have something that's really powerful to say, the power statement, just try to pause for 6 seconds. You'll never get there, but just try. Try to pause, and it just adds so much power to what you just said when you're able to pause for that long. Or if a witness says something that one of your witnesses makes a really strong statement, let it soak in by the pause. The pause adds so much power, and it's such an underused thing by trial attorneys. So I agree completely with you. It's about creating credibility with jurors and then using the power of pause in speech to really emphasize key words.